employment right protections. Most of these laws have a lot of holes and exemptions in them for so-called safety-sensitive positions and law enforcement, and of course for federally regulated positions. But I'm going to talk about our law, which I think is tighter than any of the other laws that have been passed so far, and tell you how we got there. Okay, in California, the background on this is we've long had the policy of protecting lawful conduct that occurs during non-working hours away from an employer's premises is protected theoretically under the California Labor Code. Unfortunately, this does not apply to marijuana because marijuana is not totally lawful. It's federally illegal. And there was actually a court case on this in Colorado where they had a similar protection in Colorado law, and the courts ruled, no, sorry, this is not lawful conduct. However, we also in California early on had Proposition 215 that at least seemed to protect medical marijuana use. And we had thought that this would perhaps give some protection to patients who used marijuana for medical reasons. Unfortunately, the California Supreme Court decided otherwise, and infamous decision, Ross v. Raging Wire, involved a tech employee who was getting a desk job, actually, with Raging Wire Telecommunications. And after being accepted for the job, they gave him a drug test and said, sorry, you're using marijuana, can't allow that. And he said, well, look, hey, I'm a medical marijuana patient. I need it for my back problem, which gets worse when I'm sitting at my desk. The Supreme Court ruled that Prop 215 does not specifically protect employment rights. We disagreed with the court's interpretation of Prop 215, but that is the current status of law here. As soon as that decision came down, our friend Mark Leno sponsored a bill to actually try to write medical marijuana use into the protected class of people, but that bill got vetoed by Governor Schwarzenegger. So we spent some time after that trying to think of a new bill that might perhaps address the problem once Governor Schwarzenegger was out of office. And we looked at first a medical marijuana bill that would apply under the California Fair Employment and Housing Act, FEHA. It's a very broad act that forbids discrimination in employment on account of a whole host of things: age, ancestry, color, creed, etc., disability, and medical condition. And this has been interpreted to generally protect people who use legal prescription drugs and test positive for them on the job. So if, in fact, if you have a medical prescription for opiates, generally you are excused or can be excused from a drug test if the doctor so allows. So we thought that we would try to write medical marijuana into this long list of things, just to nail it down. We ran into a lot of trouble when we tried to do that. Partially, the problem was this FEHA is sort of considered sacred text, like the 10 Commandments, and adding another thing in there, especially marijuana. You say marijuana is equivalent to race, religion, sex, and so on and so forth. That was, and so there were objections along those lines. And then there were also the problem that we saw, that all that the FEHA actually requires is if you do have a medical condition that needs a drug, you are entitled to so-called reasonable accommodation for that problem. But what is reasonable accommodation? Basically, it involves you or your union talking to management and trying to come up with a reasonable solution, whatever that is. But what is a reasonable solution? Does it mean that you have to be clear of marijuana all the time? Well, clearly not. Does it allow you to test positive on a urine test? Or what about on a blood test? Are you allowed to, smoke on the job? All of these things sort of have to be sorted out. And that left a lot of questions. And we didn't even know exactly what the full implications were. So after scratching our heads for a while, we decided to take a different tack on it and specifically target urine tests, which are the most popular drug tests that are widely abused and to deny people employment, both on the job and pre-employment situations. And, urine tests are so-called metabolite tests. They don't detect the active presence of marijuana's active ingredient, THC. They detect an inactive metabolite that your body produces called THC-COOH, or carboxy-THC, which happens to linger in your system for weeks or days. And then there are also hair tests that are sometimes used. And in that case, the metabolites can linger for months. So, we analogize this like looking for empty beer bottles in workers' trash and denying them jobs on that basis. A lot of drawbacks to urine metabolite testing, but one of the biggest objections we had is there's actually no scientific evidence at all that urine tests actually improve workplace safety or productivity. This is very surprising. There have been no FDA studies ever to show that this stuff worked. They just started implementing it without any such proof. And the studies that have actually looked at it have all come back sort of negative or equivocal or whatever. In addition, of course, urine tests are really very invasive of personal privacy. And there are a lot of other problems with it. It certainly rules out medical use of cannabis for people who use it every day and excludes a lot of qualified workers. Now, if we don't have urine tests, is there any way that people can be found, we can detect whether workers are actually impaired on the job? Because that's obviously a legitimate concern in certain safety sensitive positions. And there are. Our favorite are so-called performance tests, where you actually test people mental and physical acuity on some sort of a computer or computer tablet or something. And these have a really good record of use in certain highly dangerous professions. The problem is you can't just give a performance test to somebody blind. You have to have a record, a baseline measurement. So if you've hired somebody for the job, you test them every day, you get a baseline, and then if they suddenly perform under their baseline, they're impaired. But if you just take somebody off the street, you don't know what their baseline is. So that's a problem with those tests in general. There are, however, also alternatives to urine tests chemically, and these are tests that actually look at the presence of active THC in your system. And particularly, this THC can be found in your blood or in oral fluid, saliva, for a few hours typically, sometimes longer than a few hours, sometimes just a couple of hours. But when you see the THC in the blood or oral fluid, you know that they have used marijuana recently. Now, that does not mean that they are necessarily impaired, but it does mean that they used recently. So if you have somebody on the job and you give them an oral fluid test and it turns out positive, they probably were using, within the window of being on the job. And, that's using marijuana on the job, even if it doesn't impair you, is as verboten as like having a drink on the job, even though it doesn't impair you. So there are these alternative tests. I should also mention breath tests, which are now under development, seem to be similar to the oral fluid and the blood tests. And the oral fluid, blood tests are very hard to take. You don't want to have to take a blood test for a job, but oral fluid is easy to take. They just put a swab in your mouth. And the federal government has recently approved their use as an alternative to urine testing. And it's actually recommended now by the government as an alternative. However, the government has yet to fully approve any of the actual tests through FDA. None of them have quite gotten through all the regulatory hurdles to be approved for regular use, but they will be shortly, hopefully. So we had those alternatives. So our basic approach was to hit on have a broad employment rights bill, because now we do have legal cannabis for everybody. So we wanted to protect both adult and medical use off the job and away from the workplace. All right. And so the law forbids discrimination based solely on a positive metabolite test, which is a urine test or a hair test for cannabis. So you just can't use those two testing technologies. The other kinds of technologies are still technically allowable. And nothing in it, allows drug use on the job, obviously. Enforcement is done by the California Civil Rights Department, which oversees lots of those other civil rights that are protected under FEHA and elsewhere, and the law just took effect. There are, unfortunately, two exceptions to AB 2188 that we had to accept. The one that was most painful for us is employees in the building and construction trade who actually have a great need for medical use of marijuana for the aches and pains that they get. And but unfortunately, their union, the Construction Trades Council, is extremely powerful in Sacramento and had a very conservative leadership, which was absolutely opposed to getting rid of drug testing. Mainly, I think, on power grounds. They wanted, the union had been liked to have the leverage of offering drug testing in exchange for other benefits or something like that. And they, as I said, they were really old school. We worked on it for over a year trying to get some sort of narrower exemption. But in the end, we just had to say, all right, this one union, the Building and Construction Trades Council, objects. So we're just going to read them out of the bill. And with that, labor supported us. And then, of course, federal law requires drug testing in lots of, particularly in the transportation industry and for certain federal employment, and sometimes as conditions for funding or benefits under federal law. You're specifically required to test using urine tests for marijuana. So those are natural exemptions. Well, let me point out, though, that the Federal Drug-Free Workplace Act, which is commonly cited by employers as an excuse to do it, to require them to do drug testing, does not, in fact, require any drug testing at all. All it requires is that you have a bunch of signs around saying, hey, this is a drug-free workplace, don't use drugs here. And anything else you want to do, you can do drug testing if you want, but it certainly is not required under the Drug-Free Workplace Act. Our bill, we also was delayed a year until this year as a favor for the basically the Chamber of Commerce to give them some time to prepare and adjust their policies. And in the meantime, another bill supplementary to our own passed the legislature this last year, SB 700, which banned employment discrimination for past use, and specifically made it illegal for employers to request information on an applicant's prior use of cannabis. Regardless of drug testing, you can't ask about it either any more than you can ask about other kinds of drug habits. So that is part of the law too, and I'm putting up the actual text of the existing law as it now exists, and I'm going to turn the discussion over here to my colleague Dan Ladder, who yes, so here, who Yes, he is the principal of the latter law group.
But let me get this
in Beverly-
slideshow up on this computer.
Okay.
Stand up a minute. I'm gonna put your slideshow here, Daniel, and sit you here. Okay.
In Beverly Hills, his practice consists largely of addressing employment-related matters in a wide spectrum of contexts, including matters involving the use of cannabis in and out of the workplace. He dispenses employment advice to small and medium employers as well as to employees. And he's throughout the state of California, and he got his law degree with honors from GWU, George Washington University. Yeah, go ahead.
Thank you very
Okay,
much.
can you
yeah.
come over here
Sure.
and just, don't have any more changes to your slides because it's too late.
Thank
So
you.
here's your slides and then just hit this to advance and just to go
Okay.
back. Okay, thanks, Danny.
Thank you. I need this as well. Google Plan.
Yeah.
If anyone's wondering, no, I'm not impaired. It's just a little late. But we're coordinating here. Okay. All right, well, by a show of hands, how many of you here can say that you're not impaired, would pass the drug test? I'm kidding. I'm not allowed to ask that. And I was kidding, of course. You know, I've never been concerned. My favorite, of course, is the hair follicle test. I've tested negative on each one for the past decade. So it's again, that ends the comedy portion of the presentation. Any further laughter will be unintentional.
What is impaired?
Impaired, well, that's subject to some speculation, I suppose, but impaired means not altogether present, I suppose, to some extent. Before I get going, Dale, I wanted to ask you a question or two, if I might. I know you may be off camera, but I found a couple of things of particular interest. And by the way, I do represent employees as well as employers, probably split about half and half. Representing employers is very challenging these days when it comes to giving sound advice on employment laws, and the changes in the law, which I think are warranted, do present, however, a maze of pitfalls for employers. One that comes to mind is, you know, how do you get a test that is going to hold up against legal challenge? I'm not an expert in the area of the technology I understand is advancing, but just how far is it advancing? Because at this stage, employers are not allowed to inquire about off the premises use. What a person does in private is private and should be private. After all, it's protected by Article 1, Section 1 of the California Constitution, enacted back in 1972 or thereabouts, and individuals have a right to privacy. And that has been interpreted by the courts over many decades, of course. And it is the right to privacy that has led to recent enactment of Government Code 12954. Another AB 2188 and Senate Bill 700 as contained within that provision. And, but it does prevent challenges for employers, and we do live in a litigious society. For example, Dale mentioned that a baseline test would be possibly the best way to measure whether somebody is impaired as far as job performance is concerned. But what would you attribute the impairment to if such a test were implemented? I ask this rhetorically. Would you attribute it to somebody, I don't know, on the verge of COVID or having a cold or just, you know, not feeling well on a particular day? We all perform better on some days than others, and no matter how you establish a baseline, there's always going to be some prospect for variance that's not attributable to alcohol or to marijuana. And in order to get a sound baseline test, it would arguably take, I don't know, weeks upon weeks of providing data into a system to determine what an appropriate baseline would be for measurement. So there are all sorts of tricks. And, you know, an employer, for example, under the laws newly enacted, effective January 1, 2024, cannot take adverse action, for example, or rely on the results of a non-psychoactive metabolite test. But what happens if a test result comes back when there's just and I'm not, again, an expert on how these tests work, but let's say that there is some very nominal showing that THC was in the system of the person. Mostly the tests show negative, but is there some threshold that needs to be met as far as presence of THC is concerned for it to be significant? Let's say that a different test was to be used, for example, to, let's say, saliva. And that can be easily administered on the job, I would think. And it, from what I understand, shows results somewhat reliably for use over a period of roughly 24 hours, depending. And of course, somebody can then show a positive test for, say, THC at the job site, but may have consumed a cannabis product the prior evening. And that is none of the employer's business. But what happens if the test shows a presence and the employee is not impaired? The employee may decide to find a lawyer somewhere and take some action. The employer's done, or the employee may find a lawyer, and then the employer is going to as well, of course. But how do you calibrate all this? How do you put it in appropriate context? How does the need to respect privacy measure up against the need for an employer to run a business and to do so efficiently and to, to give, due respect to the needs of the workers, but at the same time need to make sure that the job gets done, so to speak, and in particular that the health, safety, and welfare of others on the job is protected. So it's a real juggling act, and the current state of the law does not lessen the juggling to any particular extent. In fact, in the law itself, the rights of an employer are still respected to maintain a drug-free workplace and to prevent its use, possession, consumption, et cetera. That's expressly recognized, but it's easier said than done, notwithstanding the express recognition given to that. And so it's going to be interesting for many years to come. There's probably going to be a lot of litigation that's spawned by these new laws. I certainly, from a personal standpoint, can appreciate the need for a worker who suffers pain like Gary Ross did in the case of Gary Ross versus Raging War Telecommunications. Physician prescribes cannabis and marijuana, and Mr. Ross believed that it was fine, that it was acceptable, from what I think I recall, but he certainly took the pre-employment test. He then was on the job for several days and was fired when notice came back that the presence of THC was detected, and it wasn't okay. And that was in a different time. That decision was in 2008. And while the Compassionate Use Act had been enacted back in 1996, the laws obviously have changed, in particular, with the Adult Use Act being enacted effective January 1, 2017, I believe, and so forth. There's been a lot of changes in the law, but still in that decision itself, the California Supreme Court recognized the rights of an employer to regulate the workplace. Recognize specifically, for example, that the Compassionate Use Act does not address the rights of employers and employees per se. What it does do is it decriminalized, at least under state law, in that case, physician prescribed use of marijuana. And that has changed over the years. And it's obviously decriminalized in virtually every respect as far as use goes. Of course, it's different if you're talking about manufacture, distribution, et cetera. That has not been decriminalized and obviously is highly regulated. And there is a process that one can pursue if so interested to obtain a license. So, those are, I'm just sort of riffing a little bit in candor. I have a presentation. It's a bit basic, but I'm going a little bit off that because I just wanted to impart in particular the challenges that an employer is going to face as a result of the modifications to the law. And that's fine. Lawyers are keen to assist in whatever way they can, but employers have been facing challenges of one sort or another in California for decades. But it's a place that is appealing to many people, including employers who can effectively deal with the challenges presented by various laws. Another set of laws that presents a challenge is the Fair Chance Act. And that has undergone some modification recently. That law became effective on January 1st, 2018. And it...
You want me to take you to your Fair Chance Act slide?
Okay, you can take me there, but
yeah, here it is.
There we go. Okay, thank you. All right. Thank you very much. And again, I apologize if you're trying to follow along with my PowerPoint. I'm not doing a good job allowing you to do that, but the materials are there for you to consume in one form or another at your leisure. But the California Fair Chance Act is the statewide ban the box law. Ban the box, meaning that employers cannot put a box on the application to check regarding one's criminal history. There's a very, very complex web of law and supplemented by detailed regulation that an employer has to follow in order to, a covered employer, in order to properly address the application process. And it's basically a two-step process that has been modified additionally effective October 1, 2023, there's some additional challenges that an employer has. One thing that an employer cannot do is ask about one's use of marijuana in the past, including, if I'm not mistaken, any felony convictions. That has been a change that has recently occurred, to my understanding anyway. It used to be that possibly could be addressed, but now it is not a good idea for any California employer to, unless you're not a covered employer or exempt due to, for example, under federal requirements, but it's not a place to go. And that is why it is relevant to some extent, additionally to this discussion where we're talking about cannabis and how it affects the workplace and so on and so forth from a legal perspective. The Fair Chance Act is something that any covered employer needs to be mindful of, and the scope of a covered employer has been expanded significantly effective October 1, 2023. It's now not only an employer having 5 or more employees, but it's also an agent of an employer. For example, an agent could be a temp agency. And I guess that brings to mind, well, what if I'm an employer with 2 employees, wouldn't otherwise be covered, And I resort to using a temp agency to provide another worker to me. That temp agency has, let's say, a few dozen employees, and presumably is going to be a covered employer. And that temporary agency, that temp agency is my agent. And I'm going to be bound by those actions. So this may be an area of litigation, and to be honest, I haven't studied it in great depth yet, but I do think that what would otherwise be a non-covered employer of, say, one or two employees would now potentially be covered to the extent that they engage a temporary agency to supplement the workforce. Let me see where I want to turn to.
Could I ask a question?
Certainly.
One of the more complicated exemptions in AB 2188 is it does not apply, it does not preempt state or federal laws requiring applicants or employees to be tested for controlled substances, including laws and regulations requiring applicants or employees to be tested, or the manner in which they are tested as a condition of employment, receiving federal funding or federal licensing related benefits, or entering into a federal contract. So it would seem there's a lot of room for litigation there.
It's pretty wide net, to be sure. And, at one point, an employer, may not be covered and then may be covered because of entering into an arrangement with the federal government for funding and what have you.
Does a federal contract apply to a federal subcontract?
I would think so, but that remains to be seen. There are so many things that do remain to be seen, but my gut reaction to that is yes, it probably would. Okay, let me get my glasses on here and just address, and I think we've only got a few minutes left here. I want to get to a couple of areas that I think are going to be a particular challenge. And, touched on one of these already. An employer has an employee who shows up to work visibly impaired. What should the employer do? If I'm advising the employer, quite frankly, and if health and safety of coworkers is not compromised, I'm going to say grin and bear it. Just make do, make sure if you can safeguard the health and safety of coworkers and of the impaired worker, and it's not a situation where the person is, seems to be a danger to him or herself, then, I'm going to see what type of accommodation I might need to provide perhaps for that day. But as noted in the Ross versus Raging Wire telecommunications case, and it's still true to this day, employers do need not provide for any sort of reasonable accommodation. They don't need to engage in they need to engage in an interactive process, arguably, but the reasonable accommodation is not going to be to allow for marijuana use on the premises, even if it is physician prescribed. Now, I don't think that means, by the way, that employers can't allow it on the premises. It's obviously, holiday parties, we typically will see alcohol, and, alcohol is typically not approved during work hours, but, the office party, it's there. And it is legal to consume if you're 21 or over. Well, what about marijuana use at the office party? Presumably, that's possible, or even not during party hours, but because I don't know of any law that prevents, apart from federal law, and that has been a constant, that has not changed, but I don't know of any law that prevents an employer from allowing marijuana use. However, again, that's also a hotbed of potential litigation. You have to be concerned about the health, welfare, and safety of your coworkers. And if you're going to do that, you need to apply the policy in a uniform manner. You cannot discriminate. The same thing is with CBD use, for example, which is, obviously of lesser concern, certainly as far as, health and safety of coworkers are concerned. But if you are going to, but an employer can have a policy that forbids CBD use on the premises, so long as it, at least as far as I know, that is somewhat murky, by the way. I believe it's a possibility so long as it is applied uniformly. I'm not saying I recommend that employers do that, but that is an area that's probably ripe for legal challenge at some point as well. That's unclear. And again, we've talked about, other hurdles. What type of accommodation must an employer make for a qualified but disabled worker? Allowing that worker to take marijuana, no, but allowing CBD use, maybe that is a reasonable accommodation. Maybe that will be determined at some point to legally be a reasonable accommodation, but it's unclear, at least to my knowledge. If you're going to, it's obviously wise for employers to update their handbooks. I don't care what size employer you are. Make sure that you've got policies that are compliant with the current law. Make sure in your application of your policy to the workforce that you do it consistently and uniformly, and make sure that no one's going to look over your shoulder as an employer and say, oh, you allowed this person in this classification to do such and such, but this other person, no. You want to make sure that, and it's easier said than done, but just try to be sensible in how you apply your policies to your workforce. And I don't know how much those are my main takeaways that I wanted to make. Do I?
I think we've got a question here.
Yeah, I have a few, but the first one is,
wait.
You want to come up here on the mic for the question?
if you want me to.
Yeah.
Okay.
Okay, right, will get recorded. Yeah, anyone who has a question, you could take it up here. Just right here. I just want you closer to the.
She just come up.
Notwithstanding the question.
Yeah, we're going to stand right here, right here.
Okay, got it.
No, but when you were discussing the issue related to the testing and the present impairment testing during lobby days, Dale, you had a whole spiel for us about how this is a 3 to 4 hour test. So is that accurate or not accurate?
Okay, that's a very good point, and the answer is murky because tests have different sensitivities, and it depends on how sensitive the test is. It is possible and commonly done. For example, in Spain, they use oral swab tests with a threshold of, I think, 20 milligrams or something on nanograms, and that has a window of impairment of about 3-4 hours absolute maximum. As you lower the threshold, you can get longer and longer detection. And if you have a very, very sensitive detector, you can detect oral fluid THC or blood THC for a couple of days in a chronic user. In somebody who's just using, on a casual basis, it's more like 8 to 10 hours at the common threshold that they are now recommending, which is 4 or 5 nanograms. But there's no specification that you're going to use 4 and 5 nanograms or 20 nanograms or anything. So that's really up in the air, all right? And at least you can.
These tests, these research tests.
What?
Who's doing these research tests?
There's a lot of NIDA and other, there's a growing literature of tests, test results. And again, it depends on what kind of subjects you look at in these.
Maybe we should.
Well,
Many of us consume a lot.
well, that's not a terrible suggestion,
I'm
actually.
just saying, like, what's the difference? I mean, there's probably a big difference between me and someone else.
There probably is, and there's probably a difference between somebody who, on an oral fluid test, between somebody who eats a brownie or somebody who takes a THC gelatin cap, right?
Oh.
But that hasn't really been explored, has it? No, it hasn't. I can tell you, there's a lot of open questions here. So that's, yes.
I have another quick question, but for Daniel, and I'm not.
Don't go away.
Is a rec, a doctor's rec, I'll just stand up. Is a doctor's recommendation protected by HIPAA? Like the rec that we use, that someone may use for medicinal?
I believe it's
purchases.
protected by HIPAA.
Dale, you had looked like funny.
I don't know.
Oh, I don't know that either. Someone asked me that the other day and I didn't know.
I'm not saying it with 100% confidence by any means, but that's my belief.
Is it protected by HIPAA? No.
Does HIPAA
No.
protect you from what?
I guess disclosure, I mean, from someone requesting it.
No, I mean, it's someone can ask someone, if you're the patient,
I don't think.
you have the right to disclose your medical stuff. You're not prevented by HIPAA. If somebody says to you, you have a recommendation, you want to disclose it, you should do that. It's not stop.
I think it's more. You are helping a group of patients and you want to show that you have these patients you're helping and you show the recommendation, I think is what the context is. What that's consent.
Yeah, ask for consent.
But that's it, so we would need them to waive that.
No,
That I would
without
think,
HIPAA, you really should ask.
We're being told a patient has the right to disclose their medical information. I do have a question from the Q&A from the Zoom participants. I've been asked if law enforcement is now able to use cannabis. That's, I think, is maybe another complicated answer.
Law enforcement allowed to use cannabis? We believe the answer is yes. But there may be some glitch in the law that we're unaware of that will come to our attention. We were surprised to note that law enforcement expressed no opposition or problems with our bill for the couple of years we were discussing it in the legislature. So.
I think I'm arrested.
Yeah.
Honestly, if you talk to a normal cop, like, they're like, this is dumb, and a waste of our time, like,
Also,
we don't care if it's don't if you drive either.
applications to be a police officer are no longer stopping people if they have past cannabis use. It's okay to have past cannabis, so the cop.
And I've heard some fire departments allow for current cannabis use.
It's okay to have past cannabis use. Yeah, that was a ruling. Also, the Fair Chance Act is actually mentioned in SB 700 specifically. So it's operating within the same parameters as the Fair Chance Act. So if you're able to ask about, criminal records and things under the Fair Chance Act, then that could carry over to asking about past marijuana use, is my understanding of the law. But that's yet another thing to be litigated. Perhaps,
Certainly,
yeah.
not certainly the case, so I agree.
Right, okay. Okay, well, I think we're a few minutes behind, but it was a very good panel. Thank you so much.